Now, may I have the pleasure of inviting His Lordship to deliver his address on canonical aspects of UCC.
Your Grace, Most Reverend Dr. George Anthony Swami, President of Tamil Nadu Bishops' Council and Archbishop of Chennai, Mylapore, Most Reverend Dr. Anthony Papaswamy, Archbishop of Madurai, Most Reverend Dr. Francis Callist, Archbishop of Pondicherry, Kadalur, all other bishops, distinguished guests, I am very happy to be here this morning to share with you what would be the implications of the Uniform Civil Code on the Catholic Church. I often tell my canon law students, an off lawyer is more dangerous because he knows to cut but doesn't know to stitch. Knowing of canon law will not do any good. So also, I now feel knowing canon law and not knowing fully well civil law also cannot do much good. I am not an authority in civil law. A good number of my former students are here. They are a great consolation to me in being more experts than me in civil law. Whatever I lack, they will complement during the course of this lecture. Many of the points have already been dealt with in the previous talk. I just want to go through it fast, and we have Bishop Anthony Swami of Palankotai, who knows much more the civil aspect of these discussions because of his deep study and writing. I'm sure some of the points are from his doctoral thesis and his article, and which will also enlighten us. The canonical angle, I will deal with it towards the end of this talk, towards the end. So these points we have already seen, how Ambedkar expressed his desire to introduce Uniform Civil Code, and then how many people opposed it because it will really go against the Articles 25 and 26 of the Indian Constitution. Consequently, the Uniform Civil Code was left to be implemented by the government in the future and was included in Part 4 of the Constitution as one of the directives, principles of state policy. Then what about the real meaning of personal law? And then all that is discussed there. We already had this point mentioned. Bishop Lawrence Pius already raised the issue, how the Supreme Court of India asked the Parliament to enact Uniform Civil Code again and again. And then response of the Christians, how we had a meeting already in 5th November 2016 in this very hall, and then under Archbishop Peter Fernando, and then animated by our Father Xavier Arulraj, the fear among the religious minorities that their religious freedom might be curtailed in the name of Uniform Civil Code by way of harmonizing the whole Indian society was expressed. It was felt in the meeting that time already that the Catholic Church must state that the time is not right to make the principle in Article 44 a mandatory legislation now. Okay, already Bishop Anthony Swami said about some of the government-made laws are much before our independence, in the previous century. The personal law of Christians in India, Christian Marriage Act, Divorce Act, Indian Succession Act, all this. And then in Pondicherry, Still we have the Renaissance are still governed by the French law. The French government, by its decree of 21st December 1881, authorized the natives of both the sex of all the caste, religions living in the French establishment of India to renounce their personal status. By the very fact of their renouncement, which is definitive and irrevocable, they with their wives and minor children were submitted to the civil and political laws applicable to the French in the colonies. Those who opted for the French laws are called Renaissance. They are to choose a name as family name, and that will continue to be the family name. Then I don't want to go into the details of all these laws. You may be wondering why, as a canonist, I am mentioning all these laws. These laws bind us. Of course, much leave to be desired. They need to be updated, amended. As many call it, not even amended. There must be annexed to it. Yesterday I was talking to a Supreme Court lawyer. He said, don't call it even amendment to these laws. Even that will affect us adversely. Better say that they need an annexure, he was telling. Indian Christian Marriage Act of 1872, the content of these acts, we know how about who are the persons who can marry, by whom marriages may be solemnized, things like that, time and place, ministers of religions who are licensed, all those things regarding the marriage register, and who have been licensed, penalties and other consequences when you don't follow it. And then we come to the Divorce Act 1869. This is a kind of personal law, though it is state law. Then Law Commission of India's attempt to have a comprehensive law governing marriage. These points have already been left out. Again and again, what was the mind that was repeatedly expressed? As Bishop Lawrence Pye said, there is a lot of discrimination against the female spouses and so on. Then the procedural delays, confirmation by the High Court and so on. Unified law on marriage was always felt as the need of the hour. But then there was no consensus for bringing in a comprehensive legislation. These points are there already. Then afterwards, we know how the government allows divorce by mutual consent also. Then something about the Indian Succession Act. You can go into the details of the act by which we are governed. And then the personal law on adoption and guardianship. As you know, Christians are not technically allowed this adoption, but then under the Juvenile Act, they can have a care of the children. Only by a testament they can leave it to the children. All these things are dealt with. Then we have now the Special Marriage Act of 1954, under which marriages can be registered. Then the question, important question, is that whether canon law, like Muslims' personal law, can be called the personal law of the Christians, especially the Catholics in India. Here and there, in some instances, the courts have said, very rare instances, in this case canon law says like that, so you have to do like this. Even with regard to marriage, the civil court does not accept all the provisions of canon law with regard to the validity of marriage. Here and there are some instances, for example, degrees with regard to the impediments, and these things are accepted by the court. So strictly speaking, we cannot call canon law as personal law for the Catholics in India. Some of the points are here mentioned. Okay, in the case of Lakshmi Sanyal, Sachin Kumar Dar, The Supreme Court stated that if the parties to the marriage at the time of solemnization of their marriage professed the Roman Catholic religion, the question of capacity to marry and the impediments in the way of marriage would have to be resolved by referring to their personal law and for the purpose of deciding the validity of marriage. The law of the Roman Catholic Church, namely canon law of the church, is looked into. Some importance is given to canon law in this judgment. Then can we say, okay, I already mentioned this point, that as you know, on the subject of marriage and on the subject of procedure of the declaration of nullity of marriage have a civil recognition in our country. That with regard to the marriage, yes, validity of marriage when our priest bless, but then with regard to nullity, as you know, civil law does not recognize. Okay, another case is cited. Okay, the question, what is the personal draw of Christians? In this particular case, the court asked the husband to pay alimony because canon law itself says that the separated spouse needs to be paid something. Okay, then what about the attempt to have some kind of common law for all Christians? It remains, as you know, in the form of bill. Even now, it has not been taken to be made as a legislation so far. So many attempts have been made, thanks to Cardinal Oswald Gracious and all the canonists and civil lawyers who collaborated with him. Some bills which were presented are even now pending. Marriage Bill 1994, Indian Succession Amendment Bill 1994, and then Adoption and Maintenance Bill 1994, and so on. The CBCI and NCCI decided to present separately bills for marriage. The Christian Marriage Bill 1997, Indian Divorce Bill 1997, to replace the existing legislation. Thus, in the opinion of the authorities of the Church, they do not present indeed the present bills for new legislations, but only help the government to amend, more properly have annexure for the legislation in force, so that these legislations become more effective for the members of the Christian communities in India. Then we always speak about the freedom of religion, which has been sufficiently dealt with. We have the fear, genuine fear, freedom of religion, and the practice of one's faith and religion will be not guaranteed through these new laws. Now, I dealt with all this because what is our response to the already existing civil laws in the country that affect the Christians? We do not say that they are perfect. The suggestion of the Supreme Court, the experience of the Christian community, especially our own Catholic community, lead much to be desired. I always say only the 10 commandments do not need any amendment. Thou shalt not commit adultery, no compromise. Thou shalt not kill, no compromise. Man-made laws must always be amended. Purely ecclesiastical laws can always be amended. I remember going through some of the oldest rule books of St. Peter's Pontifical Seminary of the 1940s. One of the rules says, for example, seminarians while going for walk must be led by the senior deacon. They have to observe modesty of eyes in order to edify other people and for their own salvation. Now if you tell the seminarians, they will say, why at all we have to go for modesty of eyes while going for walk, it seems, for the edification of others and for their own salvation. This is how the rule book of 1940s is written. With regard to the use of radio and all, You should not have any radio or small transistor without the written permission of the rector. It is written in the old rule. Now every room has become a theatre with the allowance of mobile. Now, if you are to maintain these rules, surely it will be ridiculous. Human norms must be always revisited according to the change of times. Law must be always subjected to do these three tests. Already addressing the civil lawyers, I was telling them, is it just? If it is unjust, unjust laws or no laws at all. Is it useful? Uttile. If it is useless, no need of these laws. Is it possible? Latin saying, ad impossibile nemo tenetur. Nobody is bound to do the impossible. Impossible. I think we have to conscientize about our own legal system, the government, the other people, that we have a very, very beautiful, time-tested legal system. But they have to be revisited. Often, as Bishop Lawrence Pius said, they speak about inequality, discrimination against women. The code, for example, has removed all these discrimination against women and men congregation. One of the guiding principles already in the 1983 code is that there should not be any discrimination between men congregation and women congregation. Simply major superior, not men religious superior and woman major superior, not at all. Only that major superiors of pontifical, clerical rights are called, also they are ordinary. That's all, because of ordination. I always say the only discrimination in the code of canon law is that Canon 1024, ordination, only a baptized male can be ordained. That is the only discrimination. Other discriminations are almost removed. Even there was discrimination between clerical congregation and non-clerical congregation. Recently the Holy Father removed that also. Even lay brothers can be superiors general of the mixed congregation of men clerical congregation. So many changes are made. If at all there is discrimination in the law of the Catholic Church, even in the laws given to us by the government, then we can change them. We are not advocating, for example, subjugation of women, inequality of treatment. One of the basic canons is Canon 204 and 208. There is the fundamental equality of dignity among all Christ faithful. Among all Christ faithful. This is fundamental. Some are called to ministerial priesthood, all right. The ministerial priesthood is called to the service of the common priesthood. Who is the greatest parish priest? He is not the parish priest who teaches, who sanctifies, who governs. That parish priest who enables the Christian community to teach, Christian community to do the praying mission, Christian community in the leadership, he is the best parish priest. So such kind of equality must be promoted, announced to the world. That is the system. In this regard, all the participatory structures must not exist, not merely in name, but they must be a really practical, functional, not material existence, but formal existence. So now, what is the solution? What is our response? We don't want a uniform civil code. You have given to us already some laws. As it was said, amend them if they are really perpetuating submissiveness, inequality, and really overdosing of too much of paternalistic attitude and really subjugating women. The churches should be surely against it, especially in the thinking of our present Holy Father. Now, possible conflicts with canon law. if UCC extends its scope, or even if it is enacted, that's what I am saying. One of the important points, I addressed the civil lawyers in ERCAT. Thanks to Father Xavier Arulraj for organizing that meeting, calling all the Catholic civil lawyers and really animating them to contribute to protect the rights of the church. It's really a wonderful initiative. One point I stressed during this meeting is this. That is canonization of civil law. Canon 22. When the law of the church remits an issue to civil law is to be followed as though it were canon law. Follow the civil law as though it were canon law. Let the people who are fundamentalistic, let the people who find fault with the church know that we respect all the civil laws of the country as though it were canon law. Only two exceptions. In fact, Canon 1290 also repeats these words verbatim. 1290 also. Civil law is to be followed as though it were canon law. Only two exceptions. What are these two exceptions? When the civil law is contrary to divine law, surely we cannot bless homosexual marriages in our churches. We cannot allow abortion and euthanasia. We cannot legalize prostitution. When the civil law is against divine law, we have to fight tooth and nail to protect the values of the gospel. Secondly, there may be in civil law equivalent provision in canon law. There may be in canon law equivalent provision to civil law. Sometimes civil law says, follow the canon law. In such cases, we have to give precedence to canon law, because civil law itself says like that. Except in these two cases, we are for following civil law. Sometimes reference is made already. We are subject to civil law, especially with regard to registration, administration of our property, paying taxes, so many things, especially with regard to many areas of our apostolate. We respect civil law. Sometimes they speak of even forced conversion. I don't know, many of the non-Christians know that canon law, for example, in Canon 748 paragraph 2 says very clearly, we have to put this when these people come and attack us. Our law, Canon 748 paragraph 2 says, it is never lawful for anyone to induce others to embrace the Catholic faith against their conscience. Our law itself says like that. You are bringing in a law, anti-conversion law. We will be punished under our own law. Please be aware of it. We never go against the state. Only when it comes to certain fundamental principles of unity, we are not able to reconcile with your values, we fight against it. In the process, we are even ready to be martyrs in that we should be able to say. So, some of the things, for example, I just highlight some of the things as canonist teaching for many years. Book 1 on general norms by my favorite book. Book 1 starts with number 1. Canon number 1 and canon number 203. Some of the students here are laughing. 7 credits, 105 hours I taught them on book 1 alone. Book alone. Okay. So in this book, especially towards the end, it deals with the ecclesiastical offices. There are specific principles and procedures with regard to them. I am afraid, already it was very beautifully expressed. There is no draft. We are hitting in the air whether it will affect it. For example, removal from office, deprivation of office, appointment to office, selection process. Slowly they will come into that. You have to follow your own thing. Not enough. We have some criteria. You know, fundamental, very basic canon like Canon 149. It says, for an ecclesiastical office, you have to be in communion with the church. in communion with the church. First qualification. Sometimes they will say, it is ecclesia, why you are appointing only this person? You are working in a place where only non-baptized are there. No ecclesiastical office. So we have to appoint, if you say, they may really come into our nose and then hit us, and then it must be suitable. The Canon says 149, it must be suitable. Idoneus. What is idoneus? What is suitable? Possess those qualities that are mentioned in law. It may be common law or universal law, it may be particular law or proper law, it may be law of the association. This is what the law says that we have to follow. So here, suitable. There is a technical qualification for each and every office. There is a moral qualification for each and every office. Technical qualification we can always verify. But with regard to moral qualification, there is always a problem. The person should have good name. How do you know he doesn't have good name? When you allow the civil courts, civil law to interfere into all these matters, we will have a hell of a problem, my dear fathers, brothers and sisters. These are the possible problems that we may face when we are giving up. Then say for example, books again on the people of God. For example, ecclesial rights of Catholics. Ecclesial rights of Catholics. Right to the sacraments, for example. So they need certain qualifications to receive those sacraments. They should be members of a particular association and follow the association. Then if they interfere in the formation of clerics and deciding about the suitability of orders, here again there will be a big problem. A seminarian can sue you. Somebody who is sent away can really file a case against you, and then due remuneration and compensation of the clergy and religious while in the congregation or outside the congregation. You may say they already know while joining the congregation they will not get anything, especially with regard to the religious. I said 282 remuneration. Then already with regard to the permanent deacons, if they don't have any other job, only we have to pay, it says. 702 is an interesting canon. Many religious major superiors are there. 702, whoever lawfully leaves a congregation, the code uses the word institute, or lawfully dismissed from the congregation, cannot claim anything for any work done in the institute. Terrible. They cannot claim, so many years I swept, I was pouring water in the garden, so many years I was a teacher. So the law is very strict, but will it stand the test of the civil court? That is a problem. But then fundamental right to life, how can you leave a person like that, having served you all along? You may have written, no, he knowingly and willingly, after becoming 18 only he signed. But it is against human life and liberty, the court may say. But then the paragraph 2 of the same canon 702 also says, the institute, however, must show equity and evangelical charity towards the members who are separated from it. I remember in Pondicherry, we had the silver jubilee of the minor seminary at St. Agnes. At that time already, all the priests contributed for the ex-seminarians fund. Ex-seminarians fund. The institute, however, the diocese, however, must show equity and the evangelical charity towards members who are separated from it. Imagine a hostile government creeping into all these spheres and troubling us and setting aside the rights of the church, even though it is enshrined in canon law, and then ruling in favor of the dismissed clergy or religious. All these things are there. Already now we have so many problems. Why to multiply problems of this regard. And then with regard to book 3, so many things, proclamation, running schools and so on. In book 4, for example, will have relevance to the denial of sacraments and the funerals. 843 says, when they are disposed, you have to give them properly prepared. When they ask for them, you have to give sacraments. 915, denial of Eucharist, we have our own law. 1184, denial of church funeral, we have our own law. How the civil law, if it is going to enact all this, will come into it. And the whole book of temporal goods. Now we have enough civil control over our acquisition and administration of properties and contracts. And imagine some more control in the name of common policy, in the name of citing the example of Hindu endowments and so on. And then sanctions, again with regard to our own judicial system within the church. All this will lead us into lot of problems. We have our personal law, we have to rectify our own canon law. As you know, the whole book 6 is completely changed from Canon 1311 to 1399. The number is maintained, but the content is completely changed. As you know, the whole procedural laws on marriage nullity, canons 1671 to 1691, 21 canons completely changed. According to the need of the hour, we change canon law if necessary. We change the government given laws if necessary and add annexure. But then do not bring in a law in the name of unity and really endanger our right to religious freedom and practice of our faith. That should be our stand, I believe. By way of conclusion, I should say the following. It's important that we understand and respect the diversity and uniqueness of each area of India. The religious pluralism and diversity need to be understood and respected. While we understand, appreciate and agree that we need to empower and ensure the dignity and rights of women, care should be taken not to infringe some indispensable provisions of canon law. While the law of the land takes precedence over ecclesial law in some cases, the sacramentality of marriage is key to the church and ecclesial law. Indissolubility, unity, all these things. The church is concerned that while it respects and follows the civil code, it cannot have the civil code infringe on the sacramentality. For that matter, an annulment or dissolution of marriage granted by the church does not have a civil effect. So many other areas of practice of faith and other matters of internal administration of the church and their members should not be endangered by UCC. If at all the government introduces UCC, Christian personal law sometimes can form a basis, as they do not take their source in any particular religion. However, there exists and continues to exist a fear among the religious minorities that the government will saffronize the whole legal system, affecting the pluralism of the cultures, faith of the Indian population. In fact, the diversity and plurality constitute the core of Indian social fabric. Thank you.
Your explanation was very wonderful, Your Lordship. Thank you for address on the implications of Uniform Civil Code. Now the floor is open for questions. We have got 15 minutes, so you can raise your interventions.
Your Excellency, in some of the cases, the civil laws seem to be very reasonable, just, and applying to persons who are being affected. Whereas the canon laws, they do not see the justice of the people, saying that God is the supreme, that He hears everything, we make marriage as a sacrament, and we introduce a lot of laws. But then practically,
okay.
people face a lot of difficulties. But when they go to the civil law, easily they are being resolved. What do you say about it? When the civil laws are more fair, more conducive to the people, will you insist upon the ecclesial law?
So thank you, Bishop. I am not shocked and surprised that such a question comes from a bishop. Preferring civil law, especially for speedier justice. Justice delayed is always justice denied. It might have been the case in the past. Now at least as soon as you make a recourse, immediately a response comes to you. And you know, if you delay, leave aside going to the higher authorities, at the level of the bishop, if you delay in taking action, you can be asked to resign and give up your office, especially with regard to the child abuse cases and other things. So church is trying to act fast. Within the church, there is a system